So everybody has muted. I don't hear any feedback anymore. Thank you. That's great. So this hearing is now called to order. I'd like to welcome everyone. This is a hearing on the Committee on Ways and Means to be sure that you're in the right hearing. Today, we will take up the proposed extension of the period to avail of the estate tax amnesty law provided by RA 11213, otherwise known as the tax amnesty law. So we have Senate Bill number 2051 filed by Senator Bong Revilla, and we also have a House bill that was forwarded to us. So for the info of all, for those who are not that familiar, the tax amnesty law provides that estates of decedents who died on or before the 31st of December 2017, who have taxes that have not been paid or accrued as of December 31, 2017, are given up to June 14, 2021. So that's barely a month from now to file their income tax return. And that is why their estate tax return, sorry. And that is exactly why we are having this hearing today, because there has been, the House has had their hearings, they passed their bill, and we've had some discussions among the senators about this issue. So we are also taking note, let me put that out there already, that the time frame given for the people to avail of this tax amnesty was roughly 2 years. I think DOF later on, or BRR, can give us the exact time that, after the rules came out. But 10 months of which yata were eaten by COVID, the period of COVID, no? So actually for the entire time that may COVID tayo, medyo affected, of course. All public services have been affected. So that's been 13 months, more or less, since March, going on 14 months. So around 14 months has been taken up. And I think what I meant, because I know there was a 10-month period, I think the 10-month period was the time that prior to COVID, there was about 10 months that they had time to file, and then after that COVID hit. So let's take that into consideration as we discuss this. So we have a number of resource persons. They have statements and presentations for the information of my colleagues, no, para alam nyo rin yung I'd really like them to be able to give their presentations first. So if you can hold off on your questions, unless of course there's something in the presentation that was not clear, by all means, go ahead. But basically, let's try to let them finish their presentations para lang we see the whole picture. So our main presenters would be from the DOF, followed by BIR, and then the Land Registration Authority, and then the Bureau of Local Government and Finance. And then we have tax practitioners. We have the Tax Management Association of the Philippines. We have a private tax firm, two private tax firms. Then we have an advocacy group, and then we have the academe. So yeah, ideally, I'd like to hear all of them first. But like I said, let's listen to the main groups, and then let's see if you really have any pressing questions or if it can wait better. Yes, Senator Amy, did you want to say something?
Yes, Madam Chair. I just wanted to make a manifestation of wholehearted and unconditional support to the extension of the tax amnesty, given the conditions prevailing during COVID. As you mentioned, 8 months, we were under all types of quarantine. And if the BIR is around, I would like for them to address the questions of implementation that have, as usual, raised their ugly head. That the BIR has been unduly stringent in the application of the tax amnesty, and that in fact they have additional or surprise requirements sprung upon those who intended to avail. Na wag sana ma-dissuade yung ganado na mag-settle ng kanilang taxes. So I just wanted that this issue was addressed, that I've heard from private practitioners repeatedly. Also, given that this is in aid of legislation, and further regarding the BIR, are there other ways that they can recommend to us such that we can hasten or simplify the procedures for this tax amnesty to encourage those to file, given the prevailing travel restrictions still during this period. Thank you, Madam Chair.
Okay, thank you. We will ensure that they respond to those questions. Yes, I'll call on Senator Frank. Please, you have the floor. And then Senator Sherwin, if you want to put out there any concerns you have. Go ahead, Senator Frank.
Well, may I request that the DOF make the first presentation? I am generally in favor of the bill, but I would like to hear the DOF because of my very traumatic experience in the CREATE bill. And they vetoed a lot of provision that they did not agree with, and because we considered the CREATE bill as a revenue measure, the president exercised the line item veto, which should not have been available insofar as the items that would fall under the incentives laws are concerned. So having said that, the first resource person, may I request, be the Secretary of Finance, so we will know how they view this bill. In general, I don't think anybody in the Senate will have serious reservations about this, but the reality is we would like to hear the views of the Secretary of the Department of Finance.
Yes, Senator Frank, they are actually the first to present, no?
Yes.
So don't worry, your request is very easily granted. Anything else?
I'll be candid, the Senator Pia. If this Department of Finance does not endorse this bill, what do you think he will do when they will do when the bill reaches Malacanang for signature?
Yes, that's a very valid concern because it's not a secret. I noted and I already reviewed the position papers of all the interest groups, all the sectors concerned from the House, and whatever was submitted. And just to jump the gun on everyone, well, everyone supports it except DOF. And so
yes.
I think I mentioned it very briefly in caucus that is why if this is concern of the senators, we have to take it up at least in the hearing level and find out. Kasi, diba, it's time and effort that is very valuable on our end given the limited session day. So, very well noted, your concern. I share the same concern.
Remember, Madam Chair, that we have only 9 session days between the time that we resume session on May 17. We have counted, we will meet for 9 session days, and then we adjourn for the 3rd session of the 18th Congress. This law, the amnesty, will expire on June 15, if I'm not mistaken. June 15. So we must rush this measure in order, if we are minded to, in order that we can have the measure in the desk of the President before June 15. But that effort will be useless if the position of the Department of Finance is that we should no longer extend the amnesty. Then I am certain that they will recommend the veto. And I am certain that the President will defer to the Secretary of Finance. So what are we doing? Unless the Department of Finance says we will not recommend a veto, unless they say that, I don't really see the point in wasting our time on this bill, given our very tight schedule after May 17. So it's very important that the Department of Finance be candid with this committee. What do you intend to do, assuming this is not a very difficult bill? It's just an extension of 2 months. Very easy. I mean, 2 years, not 2 months. So, and I think everybody finds merit in it. But if there is a basic difference of opinion between all the sectors, including the BIR, the Senate, the House, and the Department of Finance, and the Secretary of Finance, I am afraid that all of this effort will come to naught so the first thing I'll ask, with your permission, Madam Chair, is what is the position of the Department of Finance on this?
Yes, Senator Frank, I definitely will allow you to ask that first question because DOF is really the first. Let me just quickly ask Senator Win if there's anything so that we can go into the hearing proper, and DOF will be asked to respond to the question of Senator Frank. Para nga naman we can decide how we will use our time. Senator Win, anything? Should I proceed?
Thank you, Senator. Thank you, Senator Pia. Well, Senator Pia, I'm here to listen as to what are the reasons for the extension of this amnesty. Because in my initial thoughts, amnesty should be only given once, and we should be very strict with amnesties. Because if we keep on extending, if we keep on doing amnesties, the common thinking of our taxpayers is let's delay muna because an amnesty will be given anyways, or we can lobby for another amnesty, or we can lobby for an extension. So I want to listen to the committee and also to DOF and to their source person as to why do we need to extend this amnesty and what are the benefits of extending, because we stand to lose the credibility of strict tax collection if we keep on giving extensions and another amnesties. So thank you, Mr. Chair, Madam Chair.
Okay. With that, I will give the floor to DOF. Is it Yusek Tonet? I think you're the one presenting. So Yusek Tonet, please give your presentation. Given that, I'll probably break the rule then that I had just laid out about the questions later, because DOF, unless something has changed, no, DOF has a different position here. So maybe after DOF, I'll allow questions and then we'll proceed the others. So after DOF, BIR, and then LRA. But DOF, go ahead, and then I'll let the senators ask questions after you. So Yusek Tonet, yung ko yung floor.
Yes, good afternoon, everyone. I'm here on behalf of the Secretary, to discuss issues related to the proposed increase, the extension of the deadline for the estate tax amnesty. First of all, the position of the DOF is that it has no objections to the extension of 2 years. So we recognize that there have been difficulties in the implementation of the amnesty, and the revenue that we expected has not been collected because precisely of the some technicalities in the implementation. Because we recognize that it takes time to have all these extrajudicial settlement agreements and all the papers that you need. That's your all your tax decks and everything. We recognize that it takes a long time to get all of those, and then we had COVID. So the DOF has no objection to the 2-year extension of the tax amnesty. We just want to point out that in the bills, okay, basically they copied the provisions of the law, right, on the amnesty. However, we'd like to point out that there is one paragraph there that was vetoed by the president in the last bill. So that particular provision, we again express our reservations there too. It's the provision in the bill that says, provided further that if the estate involved has properties which are still in the name of another decedent or donor, the present holder, heirs, executors, or administrators thereof shall file only one estate tax amnesty return and pay the corresponding estate tax amnesty based on total net estate at the time of death of the last decedent, covering all accrued taxes under the National Internal Revenue Code arising from the transfer of such estate from all prior decedents or donors through which the property or properties comprising the estate shall pass. So that particular provision was vetoed in the last law. So it's only to that provision that we express some reservation. But as to the extension, we are in support of the extension of 2 years. Thank you.
Okay, before I give the floor to Senator Frank, because that was his question, I just want to express my relief that you're now supporting, because that's the problem that I really was confronted with, Senator Frank, because everyone wants the extension and DOF was against it. So now that I have also, because based on the position papers earlier that we had access to, you were not supporting it. So that is welcome. Senator Frank, did you want to comment or should we go ahead, given their response?
Yes, thank you, Madam Chair. Just for the record, this is a revenue measure, and the origination is in the House of Representatives. Is that correct, ma'am?
Yes, and we already have a bill from the House, Mr.
Has this been, yes, House Bill 7068 is the original bill. Has that been passed, just for the record?
Yes, it's passed and it has been referred to the Senate. It has been transmitted to the Senate.
Yes. Now, in that version of the House, I'm looking at it right now, correct me if I'm wrong, but is the veto provision in the original amnesty in the House version that was passed? Yes, it is, no? Huh? Um,
Yes, yes. The version, I think this is it. It is here in the House version. The provision that the OF is against is here in the House version.
that's right. It's if I'm not if my copy is correct, it is on page 2,
Line 14.
line 14, line 14 to line 22.
20, yes, yes. Well, 21,
So,
and then it's on.
line 21.
Yes.
Can we confirm that? The Department of Finance has stated its position expediting this, I would endorse that procedure, or I would suggest that process to the chair and to the committee. Thank you very much, Mr. Chair, Madam Chair.
Thank you very much for that, Minority Floor Leader. Would you like to make a quick reaction, Yusek Tonet, before I move on to BIR?
Well, on the procedure, I guess if that expedites it, we can recommend that the veto, assuming that that is the version that's carried, which contains the provisions that were previously vetoed. I guess we can reiterate the veto request. The OP recommend that it be reiterated. Just so we go back to status quo and we only have the extension. Thank you.
Okay. Later on, may I ask you, in the interest of moving forward, maybe it's BIR would be in a better position to answer my question. Am I coming in clear? Because I kind of hear feedback. Am I clear? Senator Frank, am I clear to you? I'm yes. Okay. Can maybe I'll ask everyone to mute. Maybe if there's somebody with the open ano. Oh yeah, no, okay na. I'll ask BIR later. I think they're in a better position than DOF to answer my question regarding that now contentious provision. What would a computation look like coming from a grandfather that would now bypass the father and go straight to the son, or let's even say great grandfather, versus, so in other words, ano yung savings nitong provision na ito when they want it to be only one estate tax return. Okay? So patingin ng computation na yan later on for our better understanding of that issue. Because from what I foresee, and may I ask everyone to keep their presentation short, kung wala ng opposition ng DOF, we can simplify this and just say we support. I'll give you 30 seconds to, emphasize whatever you want, but no need na for the mga 8 minutes kasi support na si DOF. Okay, please, yan ang request ko. Madami pang trabaho ang minority floor leader natin. Nag-hustle pa yan sa iba-ibang mga hearing. Okay, so let's move on. BIR, you're next. Assistant Commissioner Larry Barcelo. Sir, you have the floor. Sir, where are you? Cannot hear anything. Wala kayo. Mr. Assistant Commissioner Larry Barcelo, you have the floor. Hello, calling BIR.
Your Honor, may
Yes.
I speak for the BIR? This is Deputy Commissioner
Sure.
Melissa Cabreros from the
Sure.
Legal of the Bureau of Internal Revenue. As you said, to expedite the proceedings, we adhere to the policy direction of the Department of Finance, and we support for the extension of period of time to grant more availers for the tax amnesty. Just to share, Your Honor, Senator, so far, when the RA was issued, immediately the BIR issued RR 6-2019 to give availers a 2-year period to avail the tax amnesty on estate. However, the program ran continuously for the 10 months period just before the pandemic set in. So far, despite some availers, the feedback is they're having difficulty in gathering documents because of the pandemic and the restrictions in the travel. But so far, we have almost 43,700 availers and was able to generate collection of around 2.5 billion from 2019 to date. However, this is way beyond the expected target when the law was first enacted. Thank you, Your Honor.
Robert, please, you have the floor. Attorney Robert Ley Retena, are you around? If not, I will call on Bureau of Local Government. Are you there?
Yeah, good afternoon, Madam Senator.
Sir, you have the floor.
Yeah,
Yes.
good afternoon, Madam Senator Pia Cayetano and the rest of the honorable senators and members of the committee, Your Honors. Your Honor, in the same manner that the BIR and the DOF has already stated its position on the matter, that is, without any condition at all, they support the proposed extension of the amnesty. That is also the same position taken by the Land Registration Authority, it being a passive government agency that would implement the said extension law. However, I don't know if this is a matter that should be addressed by the law itself or the implementing rules and regulation. I would state that operationally, Your Honor, there are a lot of observations that were made by and were actually escalated by practitioners. These were escalated to the Land Registration Authority of the fact that the present holder of the estate belonging to, let us say, from a great grandfather to the grandfather to the father and now the present holder of the property. The basic intention is to settle the estate. Okay, that is the basic intention. But for one reason or another, they cannot get all the estate participants, meaning the heirs, to get together and come up with a palatable judicial or extrajudicial settlement. But the intention is there to beat the deadline. Okay? But the requirement of the law is that there should be a settlement first, either a judicial or extrajudicial settlement. All right? So while they are trying to beat the deadline, but because of their inability to gather the heirs of the decedent, they would not be able to settle it, and therefore, most likely they cannot beat the deadline. That is the problem. I just don't know if this scenario, Your Honor, would be best addressed by the law itself or by the implementing rules and regulation. Yun po yung problema nila. Gusto nila magbayad. There is no problem. They have the capacity. Kaya lamang, sa dami ng mga heredero, hindi pa nila alam at wala pa silang definitive solution on how to settle the estate of the late great-great-grandfather, as the case may be. So, my humble suggestion is that the payment or the beating of the deadline of this amnesty is that it should not be dependent on the fact that there should be settlement of the estate first. Anyway, babayaran naman nila ito eh. Whether or not there shall be a settlement in the future, at least bayad na sila.
Can I interject to ask for clarification on that, no? So are you saying, and later on, I'm glad that we have practitioners and advocate groups here. Are you saying that from experience, karamihan ng heirs are willing to pay, they just don't know yet how to settle it among themselves? So you're saying if they can agree, let's just say there are 6 children, and of the 6 children, yung 2 doon namatay na, so yung 2 children merong 10 apo. So you're talking about 6 plus 10, 16 people.
Yes.
And they agree in principle that we have to pay this amount anyway, and somebody there is willing to pay. Oh,
Yes.
dapat, di ba, so maybe, so you're saying that the law might need to just address that, since may magbabayad naman, kasi it's not technically a settlement yet.
Yes, because the law,
Pero they have settled. the idea of paying. That part is settled, obviously, because if not, sino magbabayad, right?
Yes, exactly.
So
Exactly,
that
ma'am.
part is settled.
Ah.
Well, I'd like
But-
to ask the practitioners later on, from experience or kahit kayo, na madali ba yun? Kasi that's like what you're saying, they are willing to pay.
yes.
So in principle, they have a settlement when it comes to the payment. Hindi lang
Yes.
sila nagkaayos pa dun sa
Yes.
akin. Marami ba
Insofar-
yun?
Marami pong ganon. Gustong-gusto na nila magbayad.
Kasi nga,
kasi
kabawasan
the idea is-
din
Yes,
sa kanila yun.
precisely.
Naman.
Exactly.
So if
Kaya
they
nga, ma'am.
are still speaking to each other, they will at least agree on bayaran na natin yung estate.
Yes, ma'am. Yes, ma'am. That is
Agree. I
correct.
see your point. Okay.
Kasi yung,
Sige, baka nga.
as the law is worded right now, there should be an attached proof of settlement of the estate, whether extrajudicial or judicial. At this
Yeah.
point, wala pa naman silang definitive settlement agreement eh. Pero gusto na nilang magbayad.
Yes,
To
got
beat
it.
the deadline.
Si Deputy Commissioner, are you still there or anyone from BIR? Ano ba?
Yes, ma'am.
Ganyan din ba ang
Yes, ma'am.
experience nyo? Ganyan ba experience?
Yes,
But again, maybe can somebody also what's the word I'm looking for? Educate us. Karamihan ba or is there even a trend? Are a lot of the estates, or would you say maybe just the bigger estates, the asset is land? Kaya mas, in that sense, mas familiar naman talaga si Attorney Robert with what he's talking about, or hindi naman? I wouldn't know. I don't know how people's estates are.
Actually, karamihan, ma'am, lupa talaga. Actually, karamihan lupa talaga. Lupa talaga.
Okay.
And
Yan yung
that's the most contentious.
Okay. And how about sige, Deputy Commissioner, and could you respond or share your thoughts on this?
Yes, Your Honor. On the part of the BIR, one of the documentary requirements that we ask is the presentation of the extrajudicial partition. This is a document co-signed by all the remaining heirs. As mentioned by LRA Deputy Commissioner, often, ang nakakarating finally sa BIR is yung kompleto ng papeles and has extrajudicial partition. But there are those we know na willing, kaya lang hindi makabuo ng extrajudicial document because either magkakagalit yung magkakapatid, ayaw pumirma.
Yes.
So but pwede rin po nga na i-focus on the payment of taxes anyways. What after is the payment of the universe of the estate tax on what the decedent left as a property. Ibang usapan naman po na yung hatian later on nung mga heirs.
So in other words, agree kayo doon. Sige, let me call on Senator Drilon first.
Just additional input, ma'am.
Oh, sige.
Okay. Another challenge by which these heirs are now experiencing is the fact that aside from the fact na hindi pa sila nagsisettle, yung status ng titulo, hindi nila alam yung mga titulo ng mga lupa ng ninuno nila. And most of them, wala silang owner's duplicate copy. And how they can settle this? How can they put it in an extrajudicial settlement and later on present it to the Register of Deeds kung wala silang owner's duplicate copy? And sometimes, hindi lang owner's duplicate copy, but yung original copy on file with the RDA, wala din. For example,
Anong suggestion nyo? Bigay kayo ng suggestion.
kaya nga mama suggestion ko, wala mo ng settlement. Wala mo ng settlement.
Okay. So as long as they agree in principle. Okay,
Yes.
let's move on lang. Let me call on Senator Drilon, and then I think this is Attorney Gonzalez after.
Madam Chair, very well. The gentleman from LRA may have valid points, but I don't think that changes the objective of the law to grant an amnesty for payment of estate tax. My suggestion is that we do not incorporate that in the law, but certainly it is a valid rule to be included in the rules and regulations, because that would involve procedure and the process and the implementation of the law. So it is a valid concern that can be resolved in the rules and regulations. Because again, while we are on that point, we note that the validity of the 2 years or the period will start upon the issuance of the rules and regulations, not upon the effectivity of the law. It says in Section 2, implementing rules and regulations, within 60 days from the effectivity of this act, the Secretary of Finance shall, in coordination with the Commissioner of Internal Revenue, issue the necessary rules and regulations for the effective implementation of this act. The previous section, section 6 on page 2, says that it is effective within 4 years from the effectivity of the rules and regulations, not from the passage of the law. And therefore, the concern of the LRA is a very valid concern, which should be incorporated in the implementing rules and regulations. And the 2-year period will not commence until the rules and regulations are approved. So then, and also if you include that here, I can assure you that will be the subject of debate and hindi natin matatapos ito by June 7. So goodbye insofar as your extension is concerned. I strongly suggest that that's a valid concern, but it should be in the rules and regulations, not in the law.
Thank you. Thank you for that, Senator Gilon. That's well taken. I definitely see your point. So let me call now on Attorney Gonzalez. Attorney Gonzalez of Ateneo Law School and Lyceum of the Philippines.
Good afternoon po everybody. Good afternoon, Senators. I agree po with the point of Director Liratano on the issue, no? But let me clarify po, when you file po an estate, there are 2 basic documents that have to be submitted. One is the partition agreement, and another one is a CPA certification as to the value of the assets. Again, we have to follow what Senator Drilon is saying, that we need to expedite this. But I would suggest po that if the BIR could be made to amend its regulations to accept the CPA certification as a basis for what the assets are, and then pay the taxes due thereon for the further submission of the EJP later on. Kasi po, the problem is, like in the example, the great-grandfather and so on, a lot of the heirs are already dead or are in the United States or can no longer be found. So difficult po just to get them to sign or agree on something. That's one point po. But we would really want the estate tax amnesty to be extended because of the fact that we were hit by the pandemic. But we want to clarify po that if you can ask the BIR to accept payments to qualify under the amnesty, even if it does not have the partition agreement, but the CPA certification as to the total value of the assets of the estate could be used as basis to pay the estate tax. Yun lang po, ma'am. Thank you po.
Noted on that. Sige, quick response from LRA.
Yeah, I perfectly recognize the point made by Attorney Kiko, my classmate at law school, and Senator Drilon. Tama po yun, pwedeng ilagay lang sa implementing rules and regulation yung the fact of whether extrajudicial settlement or judicial settlement should be presented. But I just would like to point out that even the law itself kasi, on the proviso of Section 1, provided further, very clear kasi, proof of settlement of the estate, whether judicial or extrajudicial, shall likewise be attached to the said return in order to verify the mode of transfer and other recipients. So I am willing to put the discussion in the drafting of the implementing rules and regulations, provided we delete this provision. Kasi nandito sa statute, mami, proof of settlement of the estate, whether judicial or extrajudicial, shall likewise be attached to the said return. So, if the law itself provides for a settlement, then I think in the implementing rules and regulations, we cannot just gloss this over. So I propose we delete this with this line, proof of settlement of the estate, whether judicial or extrajudicial, shall likewise be attached to the said return in order to verify the mode of transfer and other remedies. Yun lang po.
Yes, noted on that. I will get the consensus of the senators on that, but it makes sense to me. Well, let me ask Senator Frank now. Tito Frank, were you able to catch that? That the law kasi is very specific. It requires proof of settlement, and that's why the recommendation is that we delete that line, because with that line in the law, they are duty bound to demand for that document, that proof of settlement. So that's the recommendation. Yeah,
Yes,
so
Madam
that
Chair.
makes sense.
Can the gentleman point to me which line is that? I'm sorry.
I'll tell you, it's page 3, line 3 to 6. It's the last page of the extension law. Sorry, the House bill. Page 3, 3 to 6. Proof of settlement of the estate shall likewise be attached.
Okay.
If we delete that, then the rules they can do whatever proof they need by rules. But with that, I would tend to agree that the law requires that they demand that document.
Yes, I have no problems with that proposal to
Okay.
delete lines 3 to 6.
Yes. Okay, let's listen to DOF also, no? Sige. Let me call on DOF. Go ahead at Yusek Tonet.
Yes. Yeah, the suggestion is well taken, but I would just like to bring up this point no, on the essence of what is estate tax. The estate tax is basically a tax imposed on the transmission of property. So it's the inheritance is a mode of transfer, right, of property. So the estate tax is a tax on the transfer. That is the what it's for. So there has to be a transmission, whether as we said, in an extrajudicial or judicial settlement, and that's how it is in the current estate tax laws. So it's on the transmission of property from the decedent to the heir. So that's just my point on that. Thank you.
Yeah. So what you're trying to say is, without the transmission, what are you taxing? But, right, that's what you're saying. There's no act of transmission. But from a practical perspective, what so far our resource persons have been saying is that, well, there's all the desire to transmit. There's all that desire is there. It's just really a cumbersome process because people are all over the country. People have died. Maybe people are fighting. So I guess if ako lang offhand, again, I'm willing to listen to all. Unless we're violating something, and these people are willing to pay the tax, parang I don't feel naman that we're violating anything. You can even ask them to file an affidavit to say that they have all the intention of transferring, something like that. I don't know. That's probably not necessary. I see your point, because it's the act of transmission, but everybody else is saying if we wait for that act of transmission, nobody will avail. And if they do not avail, asa ka pa na they will exert, kung yung 6%, hindi nga sila makahanap ng enough effort and determination to get it done, asa ka pa na they'll get it done with a bigger tax rate. You know what I mean? So it's something, I'm not saying we should, it's something we should consciously decide on how to handle.
That's right. I see that. But I think, as I agree, that it can be addressed in the regulations without taking the provision out, because that's really the essence of it. So
pero hindi, I will disagree there though. Maybe you can ask your team, Tonet, within the day or if now. Mahirap yan. Pag i-retain yan, pag i-retain mo yon, then DIR, LRA, they are duty bound. They are duty bound to demand for this document before they move. So it's not gonna happen.
Tama.
It's not gonna happen. So parang I go back to Senator Frank's opening statement. Mag-aabala pa ba kami in the remaining 9 days if it's not gonna happen? I don't want to waste anyone's time. I don't want to waste the value time. I'd rather these lawyers are handling adoption cases, my other advocacy, you know, taking care of battered women than handling these walang katapusan ST cases because they cannot produce documents. That's the reality that we have to face. So that's where we are. Let me, you know, I'll call on you anytime naman you have additional feedback. But wait, Senator Amy, you were raising your hand, no?
Well, no. I was in full agreement with the chairwoman that until there's an amendment of this requisite, all our government agencies are required to produce them before processing the applications. Pwede bang i-amend yan sa extension?
Well, in the extension,
Or i-suspend na lang for the purpose of
the extension bill has a one-liner that we can delete, as was pointed out.
Just delete it in the meantime.
Line 3 to 6. But anyway, maybe we can go into that a little bit later. I think everybody has made their point. Is there any
Sure.
other point on this note lang? Para, okay, Senator Sherwin, and then back to LRA, and then Mr. Sorry, I don't see your name, but I'll call on you. I'll call you also, sir. Sherwin, go ahead. Senator Gatchalian.
I just want to echo in support of what Mr. Robert of LRA was saying. If you look at it, ma'am, from a cash point of view, the heirs are willing to pay. That's cash in for government already, and it's like advancing the settlement. So we get the cash and let them settle on their own. Eventually they will because they already paid. So it's to their interest to get the settlement formalized in order for them to transfer the property. But from a cash flow point of view, government has the cash. Hawak na natin yung cash. So that's it, Madam Chair.
Madam Chair, another legal input from LRA, if you may.
Sorry, I was muted pala. LRA, please go ahead.
Yes, another legal input, Your Honor, is that with all due respect to the disposition of the DOF, as far my recollection is concerned, in our laws on succession, ownership is transmitted upon the death of the decedent, whether or not it has been supported by any judicial or extrajudicial form. So yung transmission of ownership is already there upon the death of the decedent. You don't need an extrajudicial settlement or a judicial partition, as the case may be, because there is already a transmission of ownership upon the death of the decedent. Ang sabi nga sa batas, succession opens the transmission. And I mean, death opens the successional right. Yun po yung mantra dyan. From the moment of death, all the successional rights, including the right of the transmission of right of ownership to the heirs, is already done deal.
Got it. Very clear. Very clear, sir. So if I will rephrase what you just said, there is no issue on transmission because the fact of death already transmits ownership. The only remaining issue is the settlement. And that's precisely why you're saying na tanggalin nyo lang yan because the transmission has happened naman, so we can proceed with succession. Pero yung settlement lang na sila-sila, tanggalin nyo lang sa law yan because with it in the law, it's a barrier to granting this tax amnesty. Pero without it in the law, you can proceed, and there is no other legal impediment because I think if I look at the concern that you Sectonet raised, it's answered by what you said, that transmission has already happened at the time of death. That seems very clear, and I think Senator Sherwin is clapping his hands or talking to someone else. I'm not sure. Senator Frank, Tito Frank,
Yes.
you are.
Yes. Well, just to reinforce and support that idea of deleting this line from line 3 to line 6, we are talking here about the estate tax, and therefore the settlement of the estate is not theoretically involved because the estate is there. You determine the value of the estate, not the inheritance of its heir. Because if you talk about the inheritance of its heir, then probably the settlement is of the estate is a valid concern. But since this is this is not an inheritance tax, but a tax on the estate, as long as you have a determination of the value of the estate, then there is then the estate tax will be paid, and the government benefits from that collection without waiting for the settlement of the estate. It has nothing to do. This is an estate tax, not an inheritance tax. So that now, if the BIR would have other ideas that can be discussed in the rules and regulations, but I agree with the chair, we agree with the resource person that we delete lines 3, starting with proof of settlement of the estate up to line 6, ending with recipients.
Okay, thank you. Thank you for that. Yes, you further clarified that, Senator Frank. Thank you for that. Former Professor Attorney Ricalde was raising his hand. Sir, you have the floor. Former UP professor and tax practitioner.
The concerns of Senator Frank Drilon are very valid. No? Time is not on our side. So the most practical solution, I believe, knowing the concerns which are all valid of the LRA, everybody, is just to adapt the House version first, so that the deadline will be extended by 2 years. If the deadline is extended by 2 years, even if there are no new implementing rules or regulations, at the very least, it will be an extension from June 15, 2021 to June 15, 2022. Now, in that case, those who have no problems, in succession, in documentation, under the present rules, can already file. And the estate, they have 2 years, the estate tax will be paid. After all, the deadline pertains to the payment of the estate tax, not to the issuance of the certificate of authority by the BIR, which can come in later, to register the property. Much less, of course, it will not apply to the transfer itself of the title of the TCTs, which is another process which is not covered by the deadline, and of course, which will have to be done separately in the respective jurisdictions where the properties are located. So I think the solution of Senator Drilon is very practical. Let the Senate adopt the House version so that it will immediately become law before the deadline, and there will be no problems. And then let those who have no problems with the present documentation be able to settle the payment up to June 15, 2023, rather, excuse me. And then if the Department of Finance or the LRA believes that the law has to be amended, then let the process of the amendment of the law take place at that time. And after that, the law can be amended and new rules can be issued, and therefore there will be a new deadline depending upon the implementing rules, of course. In the meantime, those who are prepared to settle under the present requirements will have up to June 15, 2023 to settle this process. And later on, if there are amendments to the law as to the substantive documentary requirements, it can be done, and then new rules can be issued, and therefore every case will be settled already. We will have time to do that. But I think the concern of Senator Drilon as to the time constraint is very, very, very valid and very practical. However, I believe also that the documentary requirements are substantive and they have to be addressed in a new law. And they cannot be solved by rulemaking. And rulemaking can start in the meantime as to which are not covered by the documentary requirements. And then documentary requirements can be done by an amended law and new rules. But in the meantime, those who are prepared to settle will have a new deadline already, and they can already settle, because right now it's very, very difficult really to settle. First of all, our economy is really in a difficult strait. Everybody knows that. Secondly, the BIR, just like other offices, are in a close, open mode. And even under the present rules, and even if we are prepared to settle and pay, the heirs agree and everything, it is often very difficult to pay the estate because there are many difficulties encountered. Just like to give an example, the valuation, for example, if there are multiple properties throughout the Philippines, and there is one property, for example, in which the valuation is not agreed upon because the BIR cannot simply locate the property, and therefore the international value is rather high vis-a-vis the assessed value. There are many difficulties involved. So there is no question that the law has to be amended. And the most practical way is to adapt the House version and just to tackle the additional problems by rulemaking and or amendment of the documentary requirements later, so that those who are prepared to settle can settle already with the new deadline, at the very least, a new deadline.
Okay,
Thank you
sir.
very
Thank
much.
you. Thank you. Thank you for that, sir. So let's go back now. I think we've discussed this issue already. Bureau of Local Government Finance, Miss Brenda Miranda, are you there?
Good, good afternoon, Madam Chairperson. This is Brenda from the Bureau of Local Government Finance. During the approval of RA 11213, we received a complaint from taxpayers that they are required to pay the tax and transfer of real property tax, and including the interest and penalties. So what they were saying was that sayang daw yung amnesty dahil magbabayad din pala sila ng local tax, which is not part of the estate tax amnesty. So what we did was the Department of Finance through the BLGF issued the department circular providing the guidelines and the grant of relief and interest and surcharges and tax and transfer of real property. But syempre, the DC also coincide with the deadline of the estate tax amnesty. So if we are instructed to issue again by the Department of Finance, we will do that.
Okay, thank you very much. So let me now call on our tax practitioners, no? Let me start with Tax Management Association of the Philippines, Attorney Priscilla Valer, the president, and then after that, Isla Lipana and Company. Please be ready. So Attorney Valer, are you there?
Yes, good afternoon, honorable
Afternoon.
senators. The Tax Management Association is in full support of the 2-year extension, and we also agree with the comments made by the representative from the LRA that the requirement for an extrajudicial settlement be deleted because it is very common that the heirs are fighting, especially if it's a big estate, and that's really the big hurdle for some availers. Thank you.
Okay, thank you for that, ma'am. Next would be Attorney Maria Lim of Isla Lipana and Company. She's the tax managing partner. And then after that, please be ready, Deloitte Philippines.
Okay. Good afternoon, Madam Chair and the senators. We support the 2-year extension of the tax amnesty, estate tax amnesty availment, and also the suggestion that the reference in the bill on the judicial and extrajudicial settlement be deleted. So there won't be any more constraint in the requirement in the IRR. I think one of the concerns also, because in the IRR now, there is that section on the issuance of electronic certificate authorizing registration after the availment of the estate tax amnesty. So I think that portion of the IRR can be further amended, and that is the time that the judicial settlement or extrajudicial settlement will be required, so that the CAR or the certificate authorizing registration can subsequently be issued. Thank you. That's all.
Thank you, thank you. I was just writing my notes. Thank you. Let me now call on Attorney Tristan Lopez. And then after that, please be ready, Mark Fernandez of the Finance Philippines Seminars. And then from the academe, we'll call on our professors again.
Good afternoon, Madam Chair, Senator Tia. Sorry, my camera would not turn on my phone. Anyway, for the firm of, yes, for the firm of Navarro Ampere and Company, we are also as tax practitioners. We are in full support of the extension of the amnesty, and we are also agree that for the removal of the requirement of the extrajudicial settlement, because actually the determination of the tax happens at the time of death, and the determination of the settlement among the heirs is an entirely different matter, which should be settled among themselves. With this removal of the requirement for the settlement, indeed, the government will be able to immediately collect the tax due arising from the amnesty. Thank you.
Okay, thank you for that, Attorney Tristan Lopez. Mr. Mark Fernandez from Finance Philippine Seminars. And then after that, I'll call again on Attorney Gonzalez and then Attorney Ricalde if you have something else to add.
Good afternoon, Madam Chair. So we at Finance Page Seminars, we've been conducting estate planning seminars for a while, and most of the common concerns is on the multi-generational transfer of properties. So we would like to suggest, if we can have it retained, the suggestion was to for one generation, it will be 6%, the tax will be 6%. Like if for 2 generations, make it like 8%, for 3 generations, 10%. But as much as possible, if we can only have one form for all the generations, if it's the intention was if it's gonna reduce the taxes, we can actually have an escalating tax rate, like more generations, which would mean a higher tax rate. Also, what another concern which was noted by the
before you go on to the other concern, I'm glad you raised that. I think you're the only one, at least you're the only one I caught who raised that. May I know from the OFBIR, is the objection to that provision because of the loss revenues such that it's not acceptable to lump as one transaction or one transfer these multi-generational transfers. Therefore, it is DOF's opinion that it should be 6% from great-grandfather to grandfather, another 6% from grandfather to father, and then another 6%, because the resource person now is mentioning a discounted rate. No, you're now saying that instead of the one transaction or one transfer fee or one estate fee, discounted na lang 6 or 8. So that's kind of new. So may I hear from DOF what their main position on this is, and like, you know, is there room for there? Having said that, I don't know if there will be time to go into that. That might have to be basis for something else. I don't know. But let me hear from DOF. Yusek, can you share your thoughts on that? Yusek Tonet.
Yes. Yeah. Basically, the reason for having one rate is for simplification, or rather than and if you look into the reason for the veto, it was basically to the effect that there are multiple generational transfers of heirs, right? It actually, for practical purposes, it favors whoever is the current filer of the estate tax return, right? But it doesn't mean that he is the sole person who has all the rights to all the properties, right? So that's the issue there. That's why we don't want to um, have, and then he's gonna get a car and have it settled, right? So what if in between or before him there are other heirs who are not properly represented? So that is one issue. That's why if you have only one settlement or one payment by whoever is the filer, I mean, what assurance do we have that there are no heirs who are prejudiced by it? So that's also one practical
But
aspect.
doesn't
But I agree, your idea is very good.
yeah, sorry,
Yeah.
let me just interject, no? Issue by issue, kasi pag sabay-sabay na, may nawawala eh. I hear what you're saying, Yusek Tonet, but isn't that addressed by, well, number one, a settlement, if that's possible? I mean, there may be cases where may settlement naman sila, so clear naman yon. Or number two, not a settlement per se, but an agreement that it's going to be paid. Like, as previously discussed, even if they weren't multi-generational, even if it was just a one-generation transaction, if we're agreeing to say that, if we're agreeing to the estate tax being paid regardless of their settlement, we're not giving any benefit, undue advantage to the one who paid. We're just saying na at least nag-agree kayo to settle this, bayad na, pero you still have your own internal dynamics to figure out. So I don't quite know.
Yeah.
I'm wondering if
Yeah.
there may be sufficient language naman to address that. Because it is
Yeah,
a concern,
I think,
but I think that can be addressed because that same issue arises even if hindi multi-generational. Diba? Sila, pwede naman sila hindi nag-agree on how they're settling it, diba?
Yeah, that's right. I think what can be addressed by the regulations, because eventually, you're correct, eventually they will need that extrajudicial settlement, right, in order to get a car to transfer the title. So what can be addressed in the regulations is when that will be required. Is it at the point of paying the estate tax, or is it at the point when you get already your car? So that's something that we can change the timing of in the regulations, because you're gonna need it anyway to get to get the car to transfer the title. So that point, at that point, we can address that certainly.
But I'm not sure if I missed your response on my question as to what is your main objective? What is your main, does your objection did that veto and now the objection to the inclusion of this provision in the House bill, was it also because of the loss of revenue on a per generation transfer?
Well, that wasn't the main reason. But let me read to you the veto in the last bill. It says, while I applaud the ingenuity behind the proposal, I believe there is a need to apply the estate tax amnesty at every stage of the transfer of the property. We must take no cognizance of the rules of succession under the Civil Code of the Philippines on transmission of property rights and obligations of decedents. The tax on estates is imposed not because of the property itself, but on the privilege of transferring the property to the heirs. The flat rate of 6% estate tax amnesty without penalties imposed at every stage is more than a fair imposition of the privilege. So
So it is the intention to impose a 6% rate at every, kasi nga we've already come from a higher rate, well, graduated, but still overall a higher rate, right? That's my understanding of what you just read. That the
yes, that's
intention
right.
is 6% reasonable na yan, live with it. That's what that's I think what it said, no?
That's right. It was
Okay.
20%. And 6% is really low already.
Okay. So, and I do believe, I mean, I take everyone's comments, I give importance to everyone's comments, but that really might not be something I am capable of addressing in 3 weeks. No? So anyway, let me give thank you for that, Yusek Tunet. Let me give the floor back to Mr. Mark Fernandez. You had a second point that you wanted to raise.
Thank you, Madam Chair. So another point that we want to raise is that the timeline provided in the train law is different from the LGU code. So I think it was mentioned by the previous speaker that the transfer is from the date of death. You need to pay the LGU transfer fees within 60 days. So most of our attendees and most of the people who consult with us, the concern is they usually get to settle the estate, let's say after 6 months. So they get to be penalized for the transfer fees because the transfer fees is only 60 days. 60 days lang yung deadline, whereas the estate tax it's a year. So if I don't know if this is something that we can address with the current amnesty law, but definitely this is something that should be considered because hindi sila magkapareho yung deadlines ng LGU and sa national government. And then the third point is on the sometimes during the lockdown period there were several restrictions imposed on the transfer. So maybe we can have I don't know if this is something that we can do, but maybe an online confirmation from the BIR will be sufficient as a pass during checkpoints or because the challenge when you transfer properties is you need to go to the LGU where the property is located. So for example, you want to go to another LGU just to settle the transfer fees. You need, there are certain restrictions due to the lockdown. So this also makes it difficult for the people to really go to the LGU physically. So maybe we can have like an online confirmation from the BIR as I don't know, that's just a suggestion, but definitely it's one of the three concerns that we want to raise. That's all, Madam Chair.
Sorry, so your third one was just the ease of communicating with BIR. Tama ba yun? Did I capture that?
With the LGU side, when you want to transfer the property, you need to go to the LGU where the property is located. So, for example, I have a property in Palawan.
Yes.
My heirs have to go to Palawan, and sometimes due to the restrictions of the lockdown, they can't go to Palawan. So maybe we can have like a document from the BIR, like an online appointment form, as a proof that they can be allowed to go to Palawan to settle the property there.
Okay. What I think I will do in the interest of getting the most urgent matter settled, which is the simple extension, itong mga rules and everything, I will be happy to have a parang TWG or even just a consultative meeting where I will ask all the stakeholders to attend so that when we pass the basic law extending the extension, I don't hear later on that wala rin nangyari because all of these other little stumbling blocks or delaying practices or steps that have currently been in place effectively prevents the law from being enforced, no? So I can do that naman because not everything that you're bringing up now can be included in the law, but they are valid points in terms of getting the job done, which is extending this to the most and having the most number of people avail of it. So thank you for your input, Mr. Fernandez. Let me now go back to Attorney Francisco Gonzalez. Sir, did you want to add? You had an intervention earlier, but if you want to add anything else, you have the floor.
Hi, good afternoon again to everybody. I would just like to clarify that I defer to the position of Senator Drilon that we really need to do this as simple as possible, follow the extension, and maybe again remove that provision regarding the requirements. That's the only thing that I have to point out. There are really a lot of problems here, but hopefully with a 2-year extension, we would now have enough time to actually settle the estates of everybody. In relation to the point of Mr. Fernandez earlier, this is an issue regarding the local government code, which requires the payment of the transfer tax of real property within 30 days. Even before the train law, the estate tax was done in 60 days. So you cannot pay something in 30 days, which the national government requires in 6 months. That's before the train law. Now it's up to 1 year before you settle the estate. But the local government code says the transfer of real property must be recorded within 30 days from the death of the decedent or the settlement of the estate, which causes the problem. That's the main point I think that Mr. Fernandez is trying to point out. That's all po. Thank you very much for your time.
So it's a local government code provision.
LGU, ma'am. From the LGU.
But I mean, local government code is what's being implemented here with a different timeline. Mahirap naman talaga yun.
You pay kasi local taxes and national taxes. The estate tax is a national tax. There's a local tax po for the transfer of real property. It covers sale, donations, estate. Iba-iba yung timeline of those 3 transactions. Under LGU, it's all 30 days. Pero sa estate, it's 60 days before 1 year ngayon. 6 months before 1 year now. Sale, it's 30 days. Donation, 30 days.
Noted on that. Okay, thank you so much, sir. So, Attorney Ricalde, did you have anything else to add?
Sir, nakamute po.
The objective of this hearing should be really to extend the deadline of the payment of the estate tax. And this should be done as soon as possible because there are only so many session days left before June 15, 2021. And therefore, as suggested by Senator Drilon, a simple extension would be to adopt the House version, and therefore the deadline will automatically be extended by 2 years up to June 15, 2023. And therefore, all those who are prepared to settle the estate and to pay the estate as worded under the present rules can already commence to do that and be comforted by the fact that they have up to June 15, 2023. Now, the BIR will also have the time also late under the present dispensation to take its time to issue the certificate of authority to register. And after that, there will be a timeline, of course, to go to the respective LGUs to transfer the property already. under the names of the heirs as settled extrajudicially or otherwise. In the meantime, the rules can be amended if there are no requirements of the law, and then there will already be a new deadline there under those rules to comply with those rules. Furthermore, the Congress can also have time to introduce amendments to the law uh, to address the substantive documentary requirements. And after that, the Department of Finance can issue new rules, and there will also be, of course, a new deadline for that under the present timeline. Let us just look for practical solutions, because I don't think there is time now to address all those valid substantive documentary requirements, because indeed there are many problems being encountered with multi-generational transfers, because our laws of succession and transmission of as a mode of transmission of property is very clear. The rights of succession commences upon the death of the decedent, and that's under Roman law, passed on to the civil laws. And there's death is really, as far as succession is concerned, is final and executory. That's all there is to it. But problems on the intergenerational transfers are enough to fill a textbook, and therefore should be addressed later. But it is one thing to recognize a multinational that the transfer itself. It is also another thing to address the issue of the tax on the transfer and to cover it by amnesty. But these problems can be dealt with later. In the meantime, I believe that a simple extension by adopting the House version will do in the meantime. And later, all the other problems can be solved by rulemaking and or uh, amendments to the law, and at the same time rulemaking after that. Thank you very much.
Okay, thank you so much also, sir. Is there anyone else who would like to make any statement? I've called on all our resource persons. Any of my colleagues, any other clarification? I will definitely consult with your offices for the final version that we will come up with. I've taken note of all the concerns that everyone has raised.
Madam Chair,
Yes, Senator Sherwin Gatchalian, please.
I just have very basic questions to DOF, because I heard Yusek Tonet mention this earlier, the difficulties in implementing the amnesty. So my first question is, Yusek, what are the difficulties? I think it was discussed earlier on quite briefly, some of the difficulties, but from your analysis, what are the difficulties? And then second question is, how do you plan to solve those difficulties? And that's in line with the comment of Senator Marcos earlier, to simplify. So first question is, what are the difficulties? Second is, how do you plan to address it? Those are the questions you said.
Yeah. Yes. Thanks. Okay. The difficulties basically are with regard to gathering all the documents that are required, no, for complying with regulations requirements. First of all, I mean, it's not anything to do with the essay tax amnesty itself. it's like, let's say you have a certain family, they have a lot of real estate. It's the problem is that, of course, they have to get all the documents, gather all the documents related to all the real properties that they have. So that itself could take time. So it's the document gathering. You have to get the tax declarations and all of those things, because you have to have, first you have to establish the estate, right? If it's been many generations ago, then it is another issue. Then you have to get the valuation of those properties. Now, valuation of the estate um, refers to the time of death of the decedent. So if you have multi-generational estates, then obviously you have to get all of the valuations of all that, right? So it's the gathering of all those evidences. And then obviously you have to get in touch with all the parties concerned, like all the heirs and all that, to get them to sign the proper documents. I mean, that's also time consuming. So we recognize that. And that's further hampered by the fact that just months into the implementation of the essay tax amnesty, like 10 months or something, we already had COVID. So that further exacerbated the problem. So for that reason, we have no objection to the extension. Now, as regards what can be done, you're correct. We recognize all the speakers' inputs. Yes, certainly we would welcome the payment of the estate tax. So what we can manage is the timing when the BIR will require the extrajudicial settlement, or whatever judicial or extrajudicial settlement that will be required. Certainly, that will be before the CAR, issuance of the CAR, because the CAR is a certificate of registration to the heir. So we need to have a document to evidence the transfer. I mean, to show who the heir is, right? So that's why we need that eventually. So maybe we can ask for that document after the payment of the estate tax, but before the CAR is issued. So it's a matter of timing also, because eventually, the ultimate desire of the heirs is to get the property, the titles of the, transferred in their name, right? So you really need the CAR for that. So there has to be some document that will evidence the transfer. So I think that's something that can be fixed. It's more a timing of when it's asked for, but certainly to facilitate the payment of the estate tax, we can certainly adjust that.
You said just a quick follow-up. So do you think that proposal to parang pay now, settle later type of approach can improve cash flow collections?
Yeah, yes, certainly. And also it will make them already, so that they're this mad rush to avail of the amnesty because there's a deadline. Will stop because they already paid, right? So settling of the other issues through an extrajudicial settlement. I mean, that's there's no time limit for that. But certainly for the payment, it's only within the amnesty period. So I think what we can do is find a solution so that to facilitate the payment of the estate tax, and then for the transfer of the title to the issuance of a car, that's not covered anymore by the amnesty. That's a separate timeline already, which has no deadline. So yes, and to answer your question, if that is the way we're gonna do it, then it will certainly increase the tax collection of the BIR. And let us just point out also, our objective is not merely the tax revenue potential. What we want is also for the land to be freed up, by having it transferred already to the current, so that it can be developed, because there are a lot of properties that are stuck and nothing is being done with these properties precisely because of the high costs of estate tax.
But in fact, the settlement issue is a whole new different dynamic. You have families, you have
Yeah.
So as much as we want to free up value, but that's a whole new different dynamic. My point is, at least we have the cash already. So
Yeah, that's right. That's right. Yeah.
Okay, thank you. Thank you for this interesting exchange. I'm prepared to adjourn the hearing because we have all the input that we need to move forward. But I will propose a TWG or a consultative hearing to, like I said, hear out the other issues so that we can also assist, if necessary, on the legislation side on what we can do to expedite or to simplify or to even address any inconsistencies in different laws, including the local government code. We'll have to work with another committee on that. So on that note, I'd like to thank my colleagues for joining me today. This has been a interesting and fulfilling discussion. To all our resource persons, we thank you for the valuable time that you've taken out of your personal schedules to join us. With that, the hearing is adjourned, and please await my team, who may contact you for additional information either on this bill itself or for future consultations. Thank you very much to everyone.
Thank you.
Madam Chair, thank you.